Breaking news. Welcome to today's headlines. Why Nnamdi Kanu may be freed in court. Mike Ozekome's son. Why Nnamdi Kanu may be freed in court. Mike Ozekome's son. To my dear listeners from wherever you're listening from, please stay tuned as I read today's news. Last week, Justice Binta Niako of the Federal High Court Abuja struck out 8 of the 15 terrorism and felony charges preferred by the federal government against the detained leader of the indigenous people of Biafra, IPOB Nnamdi Kanu. Justice Niako freed Nnamdi Kanu on the 8th count while ruling on a preliminary objection filed by the IPOB leader. In this instant preliminary objection application, I have read the count and come to the conclusion that count 6, 7, 8, 9, 10, 11, 12, and 14 have not disclosed any offense against the defendant. Count 1, 2, 3, 4, 5, 8, and 15 show some allegations which the defendant has to answer. The court shall proceed to try the defendant on those counts, Justice Niako said. Consequently, the lead counsel, Chief Mike Ozekome's son, has expressed optimism that the end of the trial is within sight as evidence has proved that IPOB leader has no case to answer. In his response to members of the press, he disclosed as much as follows. So, today, 8 of the 15-count charge were dismissed, leaving 7 counts that are wobbling, counts that wobble and fumble. They will not stand and cannot hold water. You cannot build something upon nothing and expect it to stand. It is not possible. If 8 counts went, the remaining 7 cannot stand. When we look at those 7 counts, whether it's hold any water in law, we will be able to refer to the case of FRN and Saraki, where some counts were crushed by the Code of Conduct Tribunal, and the Court of Appeal tried to crush, but the Supreme Court said this is not possible because the other ones related to it should also be crushed. That was how Saraki got free. So, when you test the remaining count charge, let the prosecution get that choice. So, we proceeded to move our bail application that the defendant, Mazi Nnamdi Kanu, deserved to be granted bail. The case of the prosecution has always been that Nnamdi Kanu jumped bail, and that is why he was forcibly renditioned to Nigeria. A rendition which the court did not agree with us. We shall test it, although it is contrary to the provision of African Charter on Human and People's Rights, contrary to the Human Rights Declaration of 1948, contrary to the International Covenant on Social and Political Rights, contrary to the instrument dealing with indigenous people's rights. When you have a treaty with a country, such as with Nigeria and Kenya, and person voluntarily entered Kenya and you renditioned him forcefully through torture, inhuman and degrading treatment on the 27th of June 2021. All the cases, based on my research, shows that such person across the world cannot be tried. Nnamdi Kanu was enjoying his bail. He was within Nigeria. He never left abroad. Then, on the 14th of September 2017, the military went in armored truck as though they were going to war in Sambisa and brutally invaded the home of Nnamdi Kanu and his father, His Royal Majesty Kanu, who is now late. They murdered 28 innocent Nigerians that were there without cause. They called it Operation Python Dance. We have not seen such in Sambisa, Chibok, and Dapchi. Somehow, Nnamdi Kanu escaped. Are you saying that person who wants to be killed and ran away jumped the bill? The answer is no. It was late Chief MKO Abiola that made the statement that a bird doesn't tell another bird that stone is coming. It simply flies away. No man stands in front of a moving train. It will be crushed. Now, you are saying that Nnamdi Kanu, who barely escaped with his life, should wait in Nigeria. If he had been killed, he would not have been standing trial. So he did not jump bail. They forced him into exile, and he went as a citizen of Britain to Kenya, where he was forcefully renditioned back to Nigeria. So this is a case deserving of bail, and we implored my Lord to grant him bail if he was to subject it to certain conditions. Even under the Administration of Criminal Justice Act, bail is allowed. It is discretionary, even in capital offense like murder or treason. Mind you, Nnamdi Kanu is not standing trial for treason. He is standing trial for offenses related to treasonable felony, not treason itself. He is not standing trial for any capital punishment. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let us know what your view is all about. Thank you for listening.